A very hearty good afternoon to all of you. Dear students, in the last class, we have started the concept of uh, the co-passionary and the people who are having the right of the people who are entitled to ask for a partition, which we have seen in detail, and we have tried to analyze all the respected people who are somewhere entitled to ask for a right of partition. Okay, this we have completed. Now today we have to start a new topic, which is covered under your syllabus, how partition is affected. The word affected here means a cause or we can say something which follows, okay, how it is created, and further we can say when we talk about to cause or to bring something into being, okay, to put into operation, aftermath or the product or sequence result. So the development, these are the, we can say, the meaning which we are able to get from we can say from dictionary. So when we talk about that how partition is effective, dear students, we have to understand that we have already discussed that, and we have seen that according to the Metakshara school, partition means two things. First is the severance of the status, which means that status, the relationship is brought to an end, and division of property. When we talk about the division of property, it means that it connotes that division of property by metes and bounds. What is the meaning of the term metes and bounds? We have told, as we have discussed, that dividing the property according to its, what we can say, limitation or division, or something which is affecting it, okay, and something by which we can say we are able to precisely divide the boundaries and the limits of the property. So this is what two things are there in the Metakshara school. So when we talk about the severance of joint status or interest, we have to understand the very first thing that whenever the joint family is trying to ask, the co-partners are asking for a partition, the very first thing is the expression of intention. Something very near to what we have seen to the requisites of a valid contract. Because in the court of law, we have to analyze in that particular, we can say, sequence. The court of law, the things are read or are assumed by the legal terminology, the legal concept. The very first thing is that if suppose tomorrow the same person who asked for a partition appears or sue in the court of law asking that this particular partition is not valid, is not genuine. So the court would see the intention of that person during when the partition has taken place. The concept of intention is very crucial. Here also the very first thing is that the expression of interest. So whenever we talk about the severance of status, the court has to see whether the intention was there and how it was expressed. Now this creates a question. Why? Because we have to understand the concept of intention, that how the intention was given. So where is necessary to bring out about the severance is clear, and unequivocal expression is there. Unequivocal means which is having no doubt, which is very clear, which is we can say is free from any sort of ambiguity. This is an important element, and which this particular thing is said it can be seen, we can say, or rather can be found by words, by conduct of an intention to partition. So the important element is to check, the court will check because the issues will come to the court of law. And the people are there which we have already seen in the law of contract. The people many a times they deny that they haven't done an agreement, they haven't made it, and so on. So what happened there also, the intention is and the intention can be checked by words, by conduct, okay, of an intention to partition. So in the case of Prannath versus Rajendra, in this particular case, it was held that once members of joint family agrees or express an intention to partition, you're getting it? When once members of joint family agree or express an intention to partition, severance of status take place. So the moment the family members have agreed or have expressed their intention to the partition, severance of status, the status ends. That particular moment itself. Okay, so this is very crucial when we talk about the terms. When we try to check it, when we try to have we can say the connotation which is there. Also, the same thing has been discussed in the case of Hardoi Raj versus Shakuntala, the second case on your screen, in which it was held that once intention to partition is expressed, it results in partition. It is something very, we can say, by which the parties are trying to show or tell their intention. Such share of each co-partner becomes clear. Share of each co-partner becomes clear once it is clear that they hold the property as tenants in common and not as joint tenants. So what happened? Whenever the intention is shown, each of each co-partner, it results into the share of each co-partner becomes clear. Now what happened? The share is clear, and they hold the property as tenants in common and not as joint tenants. Okay, so dear students, we have already seen that when two or more persons own a home, they are owning a house. So either as a joint tenancy or a tenancy in common. Each individual owns a share or interest in the entire family. This means that the specific areas of the house are not owned by any one individual. When we talk about joint tenants are similar to the tenants in common in many ways, particularly with regard to their rights of possession, which is given to a right to possession to a given property. There are also minor differences. Tenancy in common is something while none of the owners may claim a specific area because they are tenants in commons. So no co-partner can say that they own a particular specific area of the property. Okay, tenants in commons may have different ownership interest. Further, tenancy in common may also be obtained at different times. So an individual may obtain an interest in the property. Here, one or more individuals have entered into tenancy in common ownership. Okay, when we talk about the term joint tenants, on the other hand, must obtain equal shares of the property. Joint tenants are the people who obtain equal share of the property with some deed at the particular time. So the terms of either of the joint tenant or tenancy in common are spelled out in the deed, title or other what we can say agreement of partition. So when we are trying to distinguish, we have to remember these particular points, that how these points are working and what are the significance of these particular, we can say, points. So when we say tenancy in common is a form of a property ownership that does not provide any survivorship rights among the co-owners or co-partners. And unlike we can say joint tenancy, one tenant common dies, the tenant interest in the property does not automatically pass to the surviving tenants in common. So it depends upon the we can say the line of difference which we have seen that each individual who's living under a joint family is either joint tenancy or tenancy in common, and each person owns a share of the entire property. And this share is not a very specific, okay, of the house or the property where they are living or the property in dispute, okay, but it is shared as a whole, which means joint tenants. While joint tenants are also similar to tenants in common, there are similarities, but we all know that there are certain differences. Again, I repeat that tenancy in common is while none of the owners may claim a specific area of the property. That is tenancy in common and may have unequal shares. So we can take the example of A is there and B is there, and each know that they are having 25% of the share at the house, and also C is there who is having 50% share in the house, in the property. So what happens? This is tenancy in common and also may be obtained at different times. So an individual may get an interest in the property years after one or more individual have entered into a tenancy in a common. Whereas when we talk about joint tenancy, on the other hand, must obtain equal share. This is important. In joint tenancy, you are having equal shares. In tenants in common, the shares are, you are knowing it, but they are not equal. Are you able to get it? I'm trying again and again, because it happens with the help of certain deeds. Maybe the deed of partition is there or some other deed is there. The terms of either joint tenancy or common are outlined in the title deed. So the deed is something by which we are able to get whether it is tenancy in common or joint tenancy. Okay. So a joint tenancy can be broken if one of the co-transfers or sell his shares to another person. So joint tenancy can be broken. I am having 25% share. I want to share it. I want to sell it. I want to, we can say, sell to someone else. And then what will result it? The result will be that a joint tenancy will be broken. And this happen also in partition. Because I am trying to sell my interest to another person. Thus, I am changing the ownership arrangement to a tenancy in common. So from joint tenancy, now what happened? Tenancy in common has taken place because a tenancy will be common for all the people. Okay, and tenancy in common can be broken also if suppose one or more co-tenants buy out the other property. The property is sold. You are getting it. So these are the various differences that in tenancy in common can be broken. The property is sold and the proceed is distributed among the owners. Now it has been sold and whatever was residue was there, it has been shared. So a partition action is filed which allows an hire to sell his or her stake. At this point, former tenants in common can choose to enter into a joint tenancy, something via written instrument or some whatever. So the title of holding of the property is most common between, we can say, the family members are there among husband, wife, and so on. So these are the things which we should remember, and they are very crucial when we talk about in terms of partition also. I thought that I should revise it because the terms are being used, and there are instances where the students get confused with these particular terms, because what happened, we have already revised it, but the question is that we have already seen it, but the question is that it is difficult for you to connect with the concept. Okay, so in this case, Hardoi Raj versus Shakuntala, it was held that once the intention of the partition is expressed it results into partition, and share of each co-partners become clear. When the share has been become clear, which means that now they have asked for the partition, and because of the partition, whatever title deed, whatever writing agreement they have gone through, and because of that, now what happens, the share becomes very clear. Okay, and the property has now in tenants in common and not, as we can say, and it is clear that they hold the property is now in tenants in common. Okay, now not in, we can say, joint tenants. So this was discussed in the particular case, and it is we can say respected, well settled law also. So the main effect which happens, the result of partition is typically, we can say, is on the property. Why on the property? Because it is the property which suffers. It is the property on which the effect takes place. It is a property, we can say, that which undergoes a change. Okay, so the Privy Council, in the case of the case I haven't mentioned because the number of cases have gone. The list of the cases is quite longer, and I want to shorten it, but somehow because I have to discuss it. So, in the case of Sayyid versus Jorawar, and it is an old case in which the Privy Council has discussed, and the same thing has been discussed in the third case, which you are able to see, Ashutosh versus Vyas Raju. And this Ashutosh versus Vyas Raju has been discussed in the year 1972. Okay, so in both the cases, the Privy Council, in the first cases was the Privy Council. So it was discussed that it was observed that it is a settled law that a severance of a state is effected of an unequal. When we say that unequivocal, it means that there is no doubt, there is no unambiguity present there. It is very clear. It is very clear. Declaration on the part of one of the joint holders. So how it is affected? It is affected. The partition is affected because of the intention, the intention of the parties by conduct or by words, which result into partition. The very first element, you have to understand it. And it may happen on the part of one of the joint holders of the intention to hold his share separately, even though no actual division has taken place. Are you able to get it? Okay. So this was discussed also in the case when we talk about when we discuss about the uh, case of car versus car. The same thing was observed in that particular case also. So in the case of Ashutosh and car, the same thing happened. The severance of status is effected of an unequivocal declaration on the part of one of the joint holders of his intention to hold his share separately, even though no actual division has taken place. This is important. And then in the case of Raghavamma versus Chinchamma, the case I haven't mentioned here. Okay, this is a case of 1964, and something similar was discussed in the case of Kamakshi versus Balakrishnan. Two cases are there, so I have chosen only one case to discuss with you. That the Supreme Court said that there must be, okay, and in the Kamakshi case but versus Balakrishnan, it is propounded the findings were of the Madras High Court, and in the case of Raghavamma versus Chinchamma, the Supreme Court said that there must be intimation, indication, or representation of intention to partition. So the important crucial element for the partition is the intention, which can be expressed by intimation. You're trying to intimate, you are trying to give a hint, you are trying to indicate, oh, I want a partition. That is an indication. You are acting as if that you are not willing to live together right now. That is an indication. Representation, you are writing, you are telling, okay, of an intention to a partition, though in what form of the manifestation of the intention is made will depend upon, it will depend upon the circumstances of each case. So the court here has said that the form of the manifestation of an intention is made, the form of the manifestation which will be made will depend upon the circumstances of the each case. Why so? Because, dear students, when we talk about the term circumstances, so each case is having its own facts, its own premises, and therefore the court has said that it depends upon the form of manifestation will depend upon of an intention, will depend upon the circumstance of each case, how it is being made. For some cases, see, we are dealing with a classical law. Right now, we are having emails and WhatsApp and God knows what. mails are there, and so many things are modes of communication are there. If suppose a particular individual is living, and at that particular of time they used to have some sort of what we can call it telegrams, and you used to have uh, telephones and so other things modes of there. The same thing which we have seen in the law of contract. When you are reading the law of contract, when you are appreciating it, it was enforced in the year 1872. That particular point of time, what was the mode of communication? You have already seen. I am not going into detail. What does it talk about? What does it mean? Are you able to get it? Okay. So the same thing applies here, dear students. What is going on? What is happening? It is something that when we can say that there must be an intimation, indication, and the form of manifestation of intention will depend upon the circumstance of each case. So it is a settled law that any adult co-partner may sever his interest by an unequivocal communication of intention to partition. Unequivocal intention. The same thing was discussed in the case of Girja versus Sudesh. That the form of manifestation is not so important. The important is the unequivocal communication of the intention to partition. Okay. And in the case of Anandi versus Nayak, also it was discussed that when father partitions, it does not mean that his minor son's interest also gets served fever. Okay. This means that the minor son is also having a right, a claim. So a co-partner who is trying to express an intention to serve to sever need not assign any reason. The reasons, the motives are irrelevant. Why I want to make a partition? The court is least bothered about this particular practice. The court has nothing to do with what they are trying to say, what they are trying to do. Nothing. The court are interested only on, we can say, on intention of the parties, and not what were the reasons. Motive becomes irrelevant. Okay. So nor does it matter in what form and what manner communication of intention is made. It is immaterial. However, the expression of a, we can say, intention must be conscious and informed act. Whenever the intention is being made, it should be made in a conscious, we can say, when the people are able to understand the consequence, there should be conscious and an informed act. You are drunken or whatever, you can say you are not in the state of your mind, and then when you propounded or when you communicated it, it may result some sort of what we can call it a confusion. Okay, sham documents or even statements, admissions serving a genuine purpose should be there. Also, in the case of Rukham Bai versus Lakshmi Narayan, this case, it was held that the statement should be and admission should be a genuine, serving a genuine purpose, and should be made in a conscious and informed manner, but made in ignorance of, we can say, correct legal position may not be satisfactory evidence of severance. If something is being done or made due to ignorance of legal correct legal position, they were not knowing the correct legal position, it may not be satisfactory evidence for severance. Are you able to get it? Okay. The same rules of contract which we have seen are applying if you are able to read in between the lines. If you are able to check it, you may find that no, it is something which we have already seen, which we have already discussed. Okay. So again, in the case of P. Perasamy versus P. Sami, it was held that mere separation from commonness does not necessarily amount to severance of status. If someone is separating from commonness, it, there is a chance that he is renouncing his interest and not he's asking for a severance for an end of the relationship. Okay, it is not if not unaccompanied by unequivocal declaration of intention to partition. So unequivocal declaration of intention to partition is a very necessary element which affects the partition, which is somewhere responsible for the creation of a partition. This is the fact we should remember. And there are issues when we are talking about a question of severance, why it is so important. I would like to uncover certain other facts also, because what happened as a joint family may make fake or notional partition to avoid the incidence of taxation also. I suppose you will be reading Income Tax Act in your fifth semester. So while you are dealing with your Income Tax Act, you may come to know that there are certain privileges, we can say special privileges, and some sort of we can say with respect to income tax has been provided for a Hindu undivided family. What happened many a times to bypass or to create mischief, people try to make a fake or notional partition to avoid the incidence of taxation. And this problem may arise under the Income Tax Act, or rather the Wealth Tax Act, because Section 171 of the Indian Income Tax Act 1971 it runs as under what have been assessment under particular section, and it is claimed whether total or partial has taken place among the members of such of the inquiries of the family. The question is, suppose the declaration of the intention to sever is made to avoid incidence of the taxation, which has to be seen with regard to a genuine partition. So where there is a genuine partition, it is a something different which the law accepts. But what happened? People try to create mischief. Okay. So this is what we have checked, and there are ample number of cases in which what we can say that the term of how the partition is effected, it has been made, and there are various cases in income tax also in which it is suspected that the arrangement was fake. So the income tax department also is, we can say, something which is running on the principles which have been propounded by the law, by the sovereign. So whether it is a personal law or whether it is a income tax act, both are having the same source, and therefore the arrangement which has been made is not something which will become inconsistent or contradict the purpose of the act. Okay, so it is established that the income tax officer also in the Supreme Court has in many cases have checked whether the partition is genuine or not, and if it is a fakeness is being given a sort of a grab of reality, probably the scrutiny has to be made, the scrutiny has to be done. But the Supreme Court have time and again has given their we can say judgments and findings that the expression of intention is mere a preference in the eyes of law, no severance of joint family status. So this is what it has been discussed, and the fakeness or genuineness of a partition should not be confused with an arrangement that a joint family may make for convenience sake, under which co-partners tries to divide the family while remaining joint. They are internally joined, and externally they are trying to show that a partition has taken place. So such arrangements are, we can say, are there, and they do not amount to partition, From them, no inference can be drawn that a partition has taken place. Okay. So I would like to continue now. There is an upcoming meeting regarding the consultation and doubt clearing. So after this meeting, I will again review in another part. Okay. Okay, I will be trying to connect again. Thank you.